Welcome to the Employment, Law, and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 223 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment law specialist and I run the firm Real Employment Law Advice, where together with my colleagues we provide advice and assistance to both employers and employees on all aspects of employment law. Our flagship service is our HR Harbour membership service for employers, where we can provide you with all of the support that you need to take away the stress and worries of dealing with employment law issues with HR and to make you the best employer you can be in your industry. If you'd like more information about our HR Harbour service or how we can help your business, please don't hesitate to get in touch. You can contact us by email. It's alison@realemploymentlawsadvice.co.uk, or you can go on our website and request a callback. It's realemploymentlawsadvice.co.uk. Now, in this episode of the podcast, I'm going to start you off with a mini-series about unfair dismissal, bringing you all the information and details that you need to know, whether you're an employee or an employer, about unfair dismissal and the law around it. The first episode is a bit of the background to unfair dismissal, and then I'll be covering off all the intricacies over the next few episodes of the podcast. If you have any questions or comments about unfair dismissal, please don't hesitate to get in touch and I will include them in the next episodes of the podcast. So without further ado, I'm going to get into this week's featured content. So in this episode of the Unfair Dismissal series, I'm going to give you an introduction. So it's going to be telling you what unfair dismissal is, what the differences are between unfair dismissal and constructive unfair dismissal, where the law comes from, some of the history to unfair dismissal laws, details about the qualifying periods in order to pursue a claim, and I'll also give you an overview about automatic unfair dismissal. So where does unfair dismissal come from and where did it start? Unfair dismissal law was introduced into the UK in 1971. And it was in the form of the Industrial Relations Act 1971. The introduction of unfair dismissal came about because of a report which was known as the Donovan Commission, or its full title was the Royal Commission on Trade Unions and Employers Associations. And that was published in 1968. And following that report, the Conservative government at the time introduced the Industrial Relations Act 1971. Now, that report came about because of a number of years in the sort of mid-60s of unofficial strike action. There was lots of unrest within employment, and the government at the time decided that something needed to be done to deal with industrial relations. And so this report was commissioned, which resulted in the introduction of unfair dismissal. One thing that the report noted, and which was one of the reasons why the report was instigated in the first place, was that between the period 1964 and 1966, there were some 276 unofficial strikes, which took place each year on average as a result of disputes about whether individuals should or should not be employed, suspended or dismissed. So when employees had no recourse if they were dismissed, there was obviously strike action by their colleagues and other employees. And what the government wanted to do was to try to prevent this from happening and obviously to make smoother industrial relations. So amongst other things, when the Industrial Relations Act 1971 came into force, it brought in this new thing of unfair dismissal. And it meant that employees could then bring a claim for unfair dismissal. Not quite in the same guise as it is now, but that was the first time that it had been introduced. And it meant that employees could receive compensation if they were unfairly dismissed. Unfortunately, the introduction of that act didn't actually have the effect that was hoped, and unions didn't really accept it, although they were generally in favour of unfair dismissal, or the unfair dismissal sections of the act. And then when the Labour government came in 1974, they repealed the act in its entirety and introduced a new act, and they reenacted the unfair dismissal elements in the Trade Union and Labour Relations Act 1974. Unfair dismissal came about as a result of a number of disputes that were taking place between employers and employees at the time as a way of resolving them and to prevent those sort of mini strikes that were taking place. So that's the history of unfair dismissal. So what is unfair dismissal and what does the law say about it now? Now, the right not to be unfairly dismissed is contained within Section 94 of the Employment Rights Act 1996. So that's the current law. And that says an employee has the right not to be unfairly dismissed by his employer. So that's it at the basic level. There are certain categories of people who don't have that right. They are, for instance, police and the armed forces. So people who are members of the police force and the armed forces don't have the right to claim unfair dismissal. They do have other employment rights, but they don't have this. Now, in order to claim unfair dismissal, an employee must have sufficient qualifying service with their employer. And that is currently 2 years. So an employee has to have been employed continuously for 2 years in order to have the right to claim unfair dismissal. Okay, subject to some exceptions, which I'll come on to shortly. Now, that changed in April. So the 6th of April 2012, the qualifying period for unfair dismissal was increased from 1 year to 2 years. And for those of you who are interested or may remember, actually, it used to be 2 years before. So it went from 2 years to 1 year. Now it's back to 2 years. So what this means is, if, again, subject to the exceptions, which I'll come on to, if an employee has less than 2 years qualifying service, they can't actually pursue a claim for unfair dismissal. Now, the purpose of unfair dismissal legislation, as I said, historically, was to try to prevent disputes. But now I think it's seen more as a way of providing employees with rights. And the idea of the qualifying period of service is that by the time somebody is employed for 2 years, you would expect to have a full understanding of whether they're any good at the job, whether they're going to be suited for the role. And after that time, there's an expectation that if an employer wants to get rid of an employee, that they must have one of the 5 fair reasons for dismissal. It's my intention to deal with the fair reasons for dismissal in the next episode of this series. But for the purposes of this one, you need to know that there are 5 potentially fair reasons. It's important to note that an employee can only claim unfair dismissal where their employment has actually been terminated by their employer. So they can't claim unfair dismissal unless they've actually had their employment ended. And if an employee wants to claim unfair dismissal, they have 3 months within which to do so. So it's 3 months from the date of termination, less a day. However, due to the ACAS early conciliation procedure, the period of time in which the conciliation is going on will extend the deadline for an unfair dismissal claim by that period. So that's covered in another episode, and also I've got some blog posts about it. But it's just to say that if you have in mind that the deadline for either putting a claim in by an employee or contacting ACAS is 3 months less a day from the date of termination of their employment. Another important thing to note about unfair dismissal is that once an employee has been employed for over a year, they have the right to request written reasons for their dismissal, and you're obliged to provide those as the employer if you receive a request. And if you have a pregnant employee or somebody on maternity leave who is dismissed, they are automatically entitled to a written statement without actually having to ask you. So if you are intending to terminate the employment of a pregnant person or somebody on maternity leave, then you would need to provide them with written reasons for the termination. So just to summarise there some of the key points about unfair dismissal. You need to have a qualifying period of service of 2 years. You can only claim unfair dismissal if the employment has actually ended. There's a time limit of 3 months to either put the claim in or to go through the ACAS early conciliation procedure. And employees have the right to written reasons if they've been employed for longer than a year. Now, what's the difference then between unfair dismissal and constructive unfair dismissal? I've already said that in order to claim unfair dismissal, you have to have actually had the employment terminated by the employer. And that's the real difference, I suppose. The easiest way of saying it is the difference between unfair dismissal and constructive unfair dismissal is that For unfair dismissal, the employer terminates the employment, and for constructive unfair dismissal, the employee would need to resign from their employment. I did cover off constructive unfair dismissal in detail in episodes 18 and 21 of the podcast, so I'll put a link in the show notes, but if you are interested in learning more about constructive unfair dismissal, then I suggest you have a listen to those. Now, with employment law, as I'm sure you are aware, there are always exceptions to the rules, and unfair dismissal is definitely one of those. There are some exceptions to the qualifying period, and these are set out within the Employment Rights Act again, under Section 108, if you're interested in having a look. And they are, if the employee is dismissed in circumstances where they would qualify for paid suspension on medical grounds, then their qualifying period is only 1 month. In most cases where the dismissal is automatically unfair, there is no need for a period of qualifying service, and I'll talk about automatically unfair dismissal claims in a moment. In relation to cases where the reason or principal reason for the dismissal is or relates to the employee's political opinions or affiliations, that means then they don't need to have the full qualifying period of 2 years. And in cases where the reason or principal reason for the dismissal is connected with the employee's membership of the reserve forces, and the effective date of the termination is after the 1st of October 2014. That gives a reservist additional protection from unfair dismissal, so they don't have to have that qualifying period. So as I say, there are 4 situations where the qualifying period of 2 years is not required to bring a claim for unfair dismissal. And one of those reasons, as I said, was in relation to automatic unfair dismissal. And in most cases, automatic unfair dismissal, you don't need the qualifying period. However, you do need to have the qualifying period of service for a dismissal in relation to a spent conviction or a GP transfer. So I'll come back to those when I give you the list of the automatically unfair reasons for dismissal. So what is automatic unfair dismissal? Well, in certain circumstances, the dismissal of an employee for one of those reasons is deemed to be automatically unfair. Okay? And what that means is there is no defence. There is no defence by the employer for that dismissal. And the Employment Tribunal has no obligation in those circumstances to consider the reasonableness of the decision. So where the Employment Tribunal establishes that the reason for the termination of the employee's employment is one of those reasons that I'm just about to list, they will have to find that the dismissal was automatically unfair. The automatically unfair reasons for dismissal are dismissing somebody for making a request to study or to train, dismissing somebody for making protected disclosures, so under whistleblowing legislation, dismissing somebody because they are pregnant or on maternity leave or maternity related, dismissing an employee because of family reasons. So that includes exercising their rights to parental, paternity, adoption leave, time off for dependents and flexible working. If an employee is a shop worker and they refuse to work on a Sunday and they're dismissed, that would be automatically unfair. If you dismiss an employee for health and safety reasons, then that would also be automatically unfair. If an employee is dismissed for taking part in industrial action, if they're dismissed for being an employee rep, also they have additional protection if they are a trade union member or if they are dismissed for a trade union membership, should I say, or union recognition, then that would be automatically unfair. Dismissing part-time or fixed-term employees because of their part-time or fixed-term status would be automatically unfair. And if an employee asserts their right in relation to the working time regulations, i.e. for annual leave, or in relation to the national minimum wage, then that would be automatically unfair. So let's just say, for argument's sake, an employee approaches their employer and says, I'm being paid below the national minimum wage, and I think it's unfair. And the employer says, okay, well, in that case, I'm going to dismiss you. Then they would, that dismissal would be automatically unfair, and the employee need not have been employed for 2 years. Dismissal, interestingly, of a pension trustee. So if somebody is dismissed for performing their functions in relation to a trustee position in the pension, if an employee is dismissed for enforcing their rights in relation to working tax credit, if they are dismissed in connection with being on the blacklist, so that's in relation to the blacklisting regulations, if they are dismissed for carrying out jury service. That would be automatically unfair. And then finally, if they exercise their employment rights. So that is to say, if they bring a claim of any sort and then they're dismissed as a result, that would be automatically unfair. And that includes the right to be accompanied. So if somebody utilises their right to be accompanied at a meeting, then they would also be protected from unfair dismissal as a result of that. And as you'll recall, it would be automatically unfair to dismiss an employee because of spent convictions and in relation to the transfer of their employment under TUPE. If they have either of those claims, although it would be automatically unfair, they still need to have been employed for 2 years. Now, the difference between having an automatic unfair dismissal case and a normal unfair dismissal case is, as I say, the employment tribunal have to make a finding of unfair dismissal and can't consider the employer's reasons behind it, etc. And in cases where somebody is dismissed for health and safety reasons, or asserting their health and safety, or for whistleblowing, or making protected disclosures, in those cases, if there is an automatic unfair dismissal for those reasons, then there is no cap on the compensation that can be awarded to them. And I will talk about compensation in a future episode of this series on unfair dismissal, but it's just to say that there is a cap on compensation awards, and in those two types of cases, so health and safety and whistleblowing, there would be no cap on the compensation. So what does that actually mean for you in practice? Well, I quite often have calls from employer clients who say, I want to get rid of this employee because they're not up to scratch. They're not meeting my requirements. I don't think their performance is any good, but I don't really want to go through the whole procedure of inviting them to a meeting and doing all of that sort of thing. And they've only been employed for a year, so, they won't have any claim for unfair dismissal. Well, I then say to the employer clients, actually, there are certain unfair dismissal claims that they could have or could infer, which would mean that they don't need that qualifying period. And so it's always really important to have a fair reason for dismissing somebody, and at least to communicate that to the employee so that they don't have an inference. So they can't draw an inference. Let's just say, for argument's sake, as an example, you have an employee who's not up to scratch performance-wise, and the reason you want to dismiss them is actually because they're no good, but you don't want to go through the procedure or tell them. And they've just so happened to have had a period of paternity leave, for instance. Now, if they then argue that they're the only person who's had paternity leave, and there were negative comments made about paternity leave, and they say, well, actually, the reason you dismissed me was because I took paternity leave when nobody else does, then it's going to be very difficult to counter that if you haven't done the correct procedure. So it's something to be mindful of when you're dealing with dismissing employees. Now, that's the introduction to unfair dismissal. So finally, I'm just going to round off by telling you about a quote from ACAS. It's one of the opening sentences in relation to their guidance for unfair dismissal for employers, and that says that dismissing employees should be the last resort. Now, I'm going to expand on that further in the future episodes of this mini-series on unfair dismissal. Now, hopefully you found that episode useful to give you the background about unfair dismissal. And if you find yourself either in a situation where you may have been unfairly dismissed, or if you're defending a claim for unfair dismissal, then myself and my team would be very happy to help you. We offer a no obligation free telephone call where we can often run through your options with you and give you some steps to get you started. If you'd like to get in touch, you can contact our head office. The telephone number is 01983 897 003, or alternatively, you can always drop me an email. It's alison@realemploymentadvice.co.uk. I hope that you have a fantastic 2 weeks ahead, and I look forward to speaking to you soon. Thanks again for listening. Just want to finalise by saying I wouldn't be a lawyer unless I had a legal disclaimer. So I must just say to you, that the information in this podcast is for information only. It's a general review and a general update. It's always necessary to get specific legal advice about your circumstances. So please don't rely on anything that you've heard in this podcast. But please do feel free to contact me if you'd like further information or specific advice.